Well, good morning, everybody. Welcome to what I think is a really exciting program of speakers and opportunities here today. I'm really looking forward to learning from all the other speakers. As Andrew mentions, we in the UK are at quite an early stage in the development of class action regimes, and we've got a lot to learn. And you'll have to forgive me if my presentation focuses on the UK and perhaps my experience. First, I intended to say something about how it's felt to be the class representative in the first opt-out collective action, the largest ever UK claim. And then I'll say something about the Class Representatives Network, the group that I helped to launch earlier this year. And finally, a few remarks about how the courts and the Competition Appeal Tribunal, UK's specialist court for these cases, affectionately known as the CAT, have been managing, including some hot off-the-press news, which I'll bring you later. So, as Bob Dylan asked, how does it feel? Well, just over 6 years ago, when I signed my claim against Mastercard, representing virtually all UK adult consumers, claiming £14 billion, that's about £300 each. As a lawyer, I was excited to be breaking new legal ground. I'd long been an advocate of allowing class actions in the UK, seeing their absence as a disgrace to our justice system. I'd been, as Andrew mentions, the UK's financial ombudsman, and I ran the service for 10 years, and I'd seen how banks and insurers could rip off millions of consumers in 3 successive scandals during my time. It was a task of my service to handle mass redress claims to ensure that consumers. As ombudsman, I had to build up a 1,000-strong staff to work on these cases. But now, being semi-retired, I was excited, yes, but also a little daunted by the position that I was taking up. Behind me was a staggeringly brilliant team of solicitors and barristers steeped in competition law. There was a billion-dollar litigation funder, expert economists whose science was pretty new to me. And confronting me, of course, was a vast American corporation familiar to consumers and businesses across the world, backed by one of the top law firms in London. And at the center of this throng of money, expertise, and talent, there was just me, a private individual with no office, no staff, armed only with a laptop. I'm remunerated modestly for running the claim, and at the end, I will just get the same as any other class member. I suppose as ombudsman, I was used to being in the public eye. Founded 20 years ago, the Financial Ombudsman Service was quite an innovation. The ombudsman role is a very personal one, holding a semi-judicial position at the center of financial dispute resolution, holding the ring between consumers and the industry. I was the same person who both judicially decided individual cases and who also appeared on TV or before parliamentary committees. The disputes that we handled were all justiciable claims that could have gone to court. So we were part of the legal system and at the same time not part. Now, the class representative role, I learned, was to be similarly very personal, but it's even more unusual. I'm not heading a company or a public body. I don't have an employment contract or a term of office. I haven't been appointed after an advertised competition for the job, nor have I been democratically elected by members of my class. My legitimacy comes from having been judicially approved by the CAT as sufficiently responsible to do the job. I can only hope that's enough for the members of my class. Being virtually the first to put myself forward for the position, I had decisions to make that would shape how the role might develop. I was acutely aware of how exposed I would be. Every decision over the course of the litigation would be mine and mine alone. Even if I eventually win, the prospect of notifying the entire UK adult population that they can come forward to claim their share of the damages I've obtained for them is also quite unnerving. Would this be subject to attempted interference or misinformation by scammers, fraudsters, claims chasers, leading to massive public criticism? Or if Mastercard were one day to approach me with a settlement offer, they haven't done yet, if I decided to accept it, my decision would have to be reviewed by the CAT, they might not agree, and class members could object if they felt I was selling them short. Hero to zero can be a very quick ride. So I decided to appoint a consultative group of individuals with extensive experience of UK consumer-related issues, from whom I can take soundings and to whom I can turn. Interestingly, all other class representatives who filed claims seem to have followed this idea of having an advisory panel, almost vying with each other now to create one with the most eminent members, some even including former judges. This now seems to be the expectation when applications are made for certification. So, back to Bob's question. How does it feel? Well, a bit like a rolling stone, I guess. It was a relief when I was able to make tentative contact with other class representatives, all on their own similar, somewhat isolated journeys. I say tentative because we'd all been drilled to be exceptionally careful not to disclose to any other human being, dead or alive, anything that could be regarded as confidential about our cases, for fear that our opposing parties could discover our conversations and use this against us. But we soon learned that there was a great deal we could say to each other without incurring these risks. And so earlier this year, 3 of us decided that there was a need to provide a space for such opportunities. And we've launched the Class Representatives Network with a website, online presence, and quite a few other things. Those involved include nearly all the representatives in the opt-out class actions that have been filed in the CAT. There's 12 of us already. All of us feel bound by a common commitment, not just to the justice of the causes that each of us are pursuing, but also to the success of our fledgling class action regime. As network leaders, I and my colleagues have made ourselves available to talk to a number of individuals who've considered or are considering becoming class representatives, asking some of the questions that such people desperately want to ask, ones that their lawyers are not necessarily the best placed to answer. Now, given the novel nature of the role, most representatives come to it with much to learn. It isn't a function or role that anyone will come to fully prepared. Representatives may come from very different backgrounds and experience. Some may have a strong knowledge of the subject matter. Others may have a legal background, like myself, but others may be familiar with competition law, which I was not familiar with, and regulation, which I am, commercial litigation, which I'm not, litigation costs, which I do know something about. But for others, everything can be completely new territory. So as a network, we are refocusing our aims and activity from being a loose contact group to being a more formal body, providing both preparation opportunities and materials for newcomers and development updates for those already busy with their own claims. Our aim is to ensure that those who act as class representatives are as well prepared as possible, have access to the knowledge and information they need, have the confidence to take up the role, and have confidential opportunities to share concerns if they arise. And as the first step on this road, I'm proud to announce today that we shall shortly be publishing on our website a guide for class representatives, which has been written by my colleague Kate Wellington. The guide provides an introduction to how collective proceedings work and their key features. It covers the authorization of representatives, the skills and experience needed, the role of lawyers and experts, litigation funding, ATE insurance. There are sections on structuring and SPVs, advisory panels, carriage disputes, settlements, hearings and appeals, and the distribution of damages. And we hope that this will provide helpful introductory information together with appropriate measures of encouragement, reassurance, and caution. And we've already published on our website a case tracker, compiled and edited by our academic consultant, Professor Rachel Mulheron. This will bring together and map the current status of all class actions brought on behalf of consumers under the collective proceedings regime. As time goes on, this will be an invaluable resource for those trying to understand how and why class actions reach the outcome that they eventually arrived at. Now, as representatives, we're remunerated quite modestly for the work we do. And to start the network, we were fortunate to get a 12-month startup grant from a charity. And it's something of an irony that we're surrounded by immensely wealthy organizations, while the money we need to run the network is only a few thousand a year, and we're not quite sure how to get it. So but anyway, we're going to be looking to develop a sustainable funding model for the network that includes both representative membership subscriptions that'll be reimbursed by funders as expenses, and also support from a sufficiently wide range of donor organizations that our independence remains clear. So anyone who wants to talk to me about that afterwards, delighted to. Now on to the cat and the courts. Let me reflect on how the Competition Appeal Tribunal and the courts are getting on with the new regime. Well, the cat certainly put me through the ringer when it refused to certify my claim and nearly derailed the entire class action regime. As a result, my then funder abandoned me, so pretty nerve-shredding time. Followed by, of course, another one in the Supreme Court, when we finally got there, when a 3-2 judgment in my favor nearly became a 2-2 when one of the 3 justices died 2 days before the decision was due to be handed down. Whew. Now, the Supreme Court's judgment has been criticized for setting the certification criteria too low. With the result, it said that the gateway of certification provides no serious test, and cases are waived through certification, and that this will ultimately discredit the regime. I'm not sure that I agree with that, but the criticisms has been made. We'll just have to wait and see, I think. In one case brought by my colleague Rachel Kent against Apple, Apple decided not to oppose certification at all. And that certainly won't be because Apple's short of money. In my case, the cat has encountered an interesting set of novel problems. Now, I'm claiming for the loss suffered by consumers in having to pay higher retail prices than we should have done as a result of Mastercard having set interchange fees which retailers, that's merchants, had to pay at an unlawful level. Now, merchants are also suing Mastercard for what they claim they lost. At present, Mastercard is defending both sets of claims. Now, how long it'll maintain that position, it will be very interesting to see. Now, in a sense, this is a classic supply chain issue, except that in most competition claims, there are usually only two levels in the supply chain in dispute. But in these circumstances, for the first time perhaps, those at the bottom of the supply chain, that is, ultimate consumers, are able to claim. This issue of costs being passed down to consumers from wrongdoers much higher up the chain will be more exposed as consumers claim to recover these losses. So market dominance abusers and cartellists better look out what's coming. Now, with different parties in the supply chain fighting each other separately, there's a real danger of inconsistent decisions being arrived at depending on the evidence available. For instance, in my case, it could be theoretically possible that in separate actions, both the merchants and my class could succeed in obtaining damages from Mastercard for effectively the same loss. Of course, if Mastercard had to pay twice, well, I'd be very sorry. I would have to agree, though, that the result would discredit our system if that turned out to be the case. So I think it won't be the case because in what I would think is quite an imaginative step, the CAT president, Sir Marcus Smith, has reached for an umbrella, not so much to protect him from getting wet, but to avoid embarrassment and avoid multiple hearings on the same issues. Using his authority as president, he's given himself powers to bring under his umbrella authority the disputes of all the parties that have common subject matters. And he's called these umbrella proceeding orders. So he'll bring my case and that of the merchants and Mastercard's to be heard together on the pass-on issue. And to satisfy his love of words beginning with U, he has taken the power to certify common matters as ubiquitous issues. Now, the word ubiquitous means things being all over the place. I think he might have chosen a better term. In the relatively short time the regime's been running, you have to discount the 2.5 years when everything was put on hold, awaiting the outcome of the appeals in my case, referred to in a way that I rather resented as Merricks induced delay, as if it was all my fault. What has been notable has been the number of appeals by defendants from CAT decisions to the Court of Appeal, and indeed the willingness of that court to entertain them. Frankly, I would say that not all of them really made out novel or important points of law. One had the impression that after the CAT error in my case, the appeal court judges mistrusted the CAT and wanted the regime development to be in their hands rather than those of the CAT, the supposed specialist tribunal. Observers might note a slightly unhappy relationship there, and one that's caused the class action landscape to feel perhaps rough and bumpy to those trying to tread through it, perhaps too many rolling stones. If every significant CAT decision is going to be appealed, how long will it take to feel that the regime is running smoothly, as its promoters might have hoped? Well, finally, to bring you the hot news of another development that might give us pause for thought. Only yesterday afternoon, in an urgent hearing in the McLaren case, the CAT was asked to consider the propriety of a defendant communicating direct to class members that McLaren says encouraged them to opt out, or was designed to encourage them to opt out. Now, notifications by class representatives to the class of their right to opt out are subject to approval by the CAT and will inevitably be framed in neutral, language, careful terms explaining their rights. Should there be any rules limiting what defendants can say to class members? Are we going to see defendants using their big budgets freely to launch counter-campaigns with attack ads in the media? Google, Apple, Facebook are all defendants in UK claims, and of course they've got their own mass communication channels. The class representative has to submit a budget for specified notifications to the class. Should defendants be able to use unlimited budgets to say anything, whether accurate or misleading, to fight class claims in the media? Or will defendants have their freedom of speech curtailed when a class action is launched against them? Well, I have to say that having looked at some of the hearing online last night, Sir Marcus Smith seemed very troubled by all of that, and not surprisingly, he's reserved judgment. So I'll leave you with those thoughts and questions to ponder on, and thank you very much for your attention. I very much look forward to meeting many of you during the course of the next 2 days. Thank you very much.